News First, Newsline.
Hello there, a very good evening and welcome to another edition of Newsline. We're coming to you live and direct from our News First studios here in Colombo. Tonight on the show, we've got with us, of course, parliamentarian from the Tamil National Alliance, President's Council, M.A. Sumanthiran. A very good evening, sir, and welcome to the show.
Good evening to you.
Thank you very much for taking time off your busy schedule. Of course, these days are quite important for the country, especially with many pieces of legislation being challenged before the Supreme Court. And I know that you are representing certain factions in that. So let's just leave that out of the discussion and get right into a judgment that was delivered in a matter that you appeared before the Supreme Court. The case against Nasir Ahmed filed by the party in which he was expelled. He challenged the expulsion. It didn't quite go in his favor. President's Council M.A. Sumanthiran, can you tell us a little bit about the significance of this judgment and what does it really mean for parliamentarians? Does it mean that now parliamentarians cannot cross over from their party because they will be kicked out of the party and as a consequence of that lose their parliamentary seat?
No, it doesn't quite work that way. You see, the electoral system that we have gives the people the choice of giving a mandate to the political party, not to individual MPs. So that's where this whole thing revolves around. So that is why our constitution says that if a political party removes an MP from the political party, he automatically loses his seat.
Okay.
That's the main provision in the constitution. Article 99(13)(a) says that. But then there is a proviso. The proviso says, but that won't take effect for a period of 1 month, and within that 1 month, if the MP concerned goes to the Supreme Court and challenges his expulsion, until Supreme Court delivers the verdict, he can remain an MP. Supreme Court must deliver the verdict within 2 months. And if the Supreme Court holds that his expulsion was invalid or was wrong,
On are the grounds specified?
no ground specified, then he gets to remain an MP. But if he if the Supreme Court holds that the expulsion is valid, then from that moment onwards he loses his seat.
It doesn't take place retrospectively.
No, not retrospectively, from that point onwards.
Okay.
So what happens in our country is that people cross over, and when the political party takes this very action and removes them from their membership, they go to the Supreme Court, they file these proceedings, and unfortunately, apart from the very first case of Lalita Tatmali and Government Sanayaka, I think all of the other cases subsequently went in favor of the MP.
Okay.
Right. So this is significant for the reason that after 32 years, one decision has come from the Supreme Court in favor of the political party, that the expulsion was valid. So that is the significance of this judgment. Of course, depending on the facts and circumstances of each case, decision can go towards MP or decision can go towards a political party. But because of the fact that for 32 years the decisions have always gone in one direction, there has been a sense of what shall I say, a belief amongst MPs who cross over that even if the party sacks them, they can go to court and they can remain in parliament. And now that has been shaken, I think.
So usually, President's Council Sumanthiran, when these decisions are given in favor of the parliamentarian who left the party and crossed over, is it on grounds of they being denied, a fair hearing? Is it grounds of natural justice? What are the reasons? Usually?
Almost always it's on that basis that natural justice has not been afforded, and in some cases some technicality. For instance, now after the Nazir Ahmad's case, Venerable Athurelia Ratana's case, he won the case, where I think they held that the body that can actually remove him from the party was not the one that did it.
Okay.
There is an MOU between two political parties or something like that.
It's a bit of a convoluted situation.
Yeah, so there have been technicalities like that. One in concerning the TNA some time ago, Para district MP PSN crossed over, we sacked him, and there the Supreme Court held with him because the disciplinary inquiry committee itself recommended that he be removed from the party, and the General Secretary carried it out.
Okay.
The Central Committee authorized the General Secretary to give effect to the disciplinary committee's recommendation. But court held no, the recommendation should have come back to the Central Committee. It is only the Central Committee that could have sacked.
So the Central Committee can't delegate their powers to the General Secretary.
Yes, that's right. So lots of technicalities like that, or a proper hearing was not afforded. Now, in Nazir Ahmad's case, one important factor is that no formal hearing was given. I argued that it was not necessary. In that case, that a formal hearing was not necessary, and court held with us.
That is because the party took a stern decision to vote against the budget. However, he went and voted for the budget. Prima facie.
And his only defense was that he did not know the party's decision. He didn't have any other defense. His only defense was that he did not know that the party took this decision, and that was shown to be false.
So, but what does this really mean to parliamentarians in the future? Now, you said, of course, they will be more wary when they cross over. Does it mean that the Supreme Court has now set a certain high level of procedural requirements, at least to sack a parliamentarian from the party? Does it mean that we can see more cases going in favor of the party in the future?
Well, that depends on facts and circumstances of each case, but what I think can happen is that if the party affords a MP a hearing or gives him the opportunity of a hearing, and there are no technical defects in the way they carry out their functions, then breaching party discipline will be good enough reason for his sacking. I think that is the precedence that comes out of this case, that a party's decision he breached.
Okay.
Right. Breaching a party decision is good reason for removing from the party.
So, does the judgment have any reference to maybe instances where, say for example, a parliamentarian strongly believes that a piece of legislation is required for a country and his conscience does not allow him to vote against that piece of legislation? However, the party has decided to vote against the legislation. Do you think that would be a valid defense?
Yeah, well, that's a point that has never been considered by court. I think that should have been considered in every case previously. There are two theories. This conscience theory is one. The other is the mandate theory. Now, that is why I started by saying this matter revolves around our electoral system, where people give a mandate to the political party or independent group and not to individual MP.
Individual is only given a nomination.
He is given a nomination, people vote for the party, and it is on the votes given to the party that a decision is made as to how many MPs from that party get into parliament. The preference votes that they get is secondary. That is in the order of preference within that group. You know, if a person has come second and they get 2 seats, he also gets in. But the fact that they got 2 seats is because people voted for that party first. In the original system, there was no preference votes also. The party general secretary decided who goes into parliament. People only voted for the party. Right? Preference was later brought in. So, the system is one where the political party reigns supreme. But of course, as you rightly asked the question, in a given situation, if a particular MP feels that the party is wrong, that he you know, out of his own conscience cannot toe the party line, now that issue has never been discussed in any of the cases before, but I think that is an important area to go into and decide how much of conscience vote is possible. And also, but in some of these cases they have emphasized that you must first take up the matter internally
within the party.
Okay. That is important.
So, there is a burden put on the parliamentarian also to bring this to the notice of the party, to bring up their objections.
That is right. And the issue concerned must be debated within the party first. If he does not do that and then come and claim that you know, I had a conscience issue, you know, conscientious objection to this and that is why I did this, then he might have a problem. Right. So, internal party democracy is also a crucial element in this. If he was denied that opportunity within the party, then I suppose he may succeed in claiming that he tried to raise it within the party. The party shut him out, and so he had no other option.
So, what does this mean now? We know that in the current Sri Lankan parliament, there are quite a number of crossovers. There are people who are in the government from the SLPP who have moved to the opposition. There are people in the opposition who have moved to government. What does this judgment mean to all of them?
Well, it only means that in each of the case, a decision can be made by the court depending on the facts and circumstances of that particular case. It is no longer possible to think that in all the cases the MP will succeed.
So, say for example, now several parliamentarians moved from the opposition to the government, as I said before, and they have already been suspended by their parties, and there might be or there could be, or at least there should be matters pending in court, because otherwise they can't obviously retain their parliamentary seat. What if they commit a further violation, a second violation of party discipline, of a party decision? Does the previous suspension really handicap the party from suspending them again?
It can sack him again.
So then that parliamentarian or that relevant parliamentarian would have to file another petition in the court. So for every single violation of party discipline,
party can do that.
So in your view, now you are not only a President's Counsel who has appeared before the Supreme Court and of course canvassed all of these arguments, you are also a parliamentarian. So you get the best of both worlds. You know how it feels like to be on both ends. What do you think regarding the development of the law in this field, at least when it comes to parliamentarians walking across the floor, because that has been quite a massive issue in Sri Lanka, at least in the context of the 52-day government that was
personally my personal view is that you cannot shouldn't be able to cross over. As I said, I am repeating this again, you are an MP only because people voted for your party, right? And so I have said this in court as well. When it was told by another counsel that I might cross over one day, I said, well, if I have to do that, I'll first resign from my parliamentary seat. I think so long as this system, the PR system remains, I don't think there can be I mean, there is always a case, that extreme cases, but generally speaking, I don't think you can easily justify a crossover. That should not be permitted. Because when people vote, they take this very seriously. They decide to vote for a party, for a particular stand that the party is taking. Right? They might cast preference votes, that's another matter. But then once you get in, you, for ministerial perks and various other factors, you just cross over. That's a betrayal of the mandate that the people have given. So, given us, if it was a first past the post system, yes, then you have, when people vote, they know whom they are voting for, the person concerned, and so there is a greater leeway for him to claim that he is acting on behalf of the people. But in this system, I don't think that that exists, unless of course there is a very extreme case where the political party itself betrays the mandate that the people give, and an MP stands aside and says, no, this is a mandate that the people gave. So to answer to your question is that, I mean, my personal view is that crossovers should not be permitted, and as you rightly said, people are disgusted over this pole vaulting by MPs. I have said this in Parliament too, in the current Parliament, at a particular point in time, or even now sometimes, we are not sure who is on which side, right? Might as well, I mean, you see, in our parliamentary tradition, there is an aisle,
right?
A very clear divide, right? And you are not supposed to cross the aisle. Our standing orders say you mustn't cross the aisle. But now it is like the Colombo Municipal Council. You might as well have round rear end and not have an aisle. Everybody gets together and elect a mayor and all sit round together and have a conversation. Yes. So that has been, there's so skewed that people are just walking across this way, that way, and that's not right. I mean, in the particular system that we have of a government and opposition and a definite clear divide, you can't have it in this way, people going this way and that way.
But in your personal view now, there was quite a shameful situation as far as the Parliament of Sri Lanka is concerned, when even one of our former presidents made a statement saying that parliamentarians are selling for 200 to 300 lakhs, and that's one of the reasons why we can't secure enough support in Parliament. Do you think that this judgment would at least pave the way for this culture of crossing over for bribes and perks and privileges to an end?
Yeah, well, I think I think this judgment, if it has done anything, it has run a chill down a lot of people's spine, wondering now, am I going to lose my seat, or better in the future people will think twice before they cross over.
Also, with regard to the constitutional provision, of course, for a parliamentarian to file action in the Supreme Court within a month, and for the Supreme Court to decide a matter within 2 months. Now, we know we have certain statutory time limitations that have been imposed on various courts. However, as to whether or not this is strictly followed is a different matter entirely. Do you think that there would be an issue where a person files a petition and maybe the pendency of the case outlives his parliamentary term, which in turn would render the entire proceedings in the Supreme Court moot.
Yes, that has happened a number of times. That's very unfortunate. The workload in the Supreme Court is really heavy these days. So, as a result of that, perhaps it takes longer than the prescribed time. But what happens there is, I looked up the first few cases. The very first case, there long judgments have been written by two judges or three judges wrote, and they delivered the judgment a day before the 2-month period ended.
Okay.
So, they were so conscientious and
about the 2-month period.
About the 2-month period.
Right.
I am not saying that the current judges are not conscientious. It's just that the workload is really heavy. But what it does,
not humanly possible.
It is not possible. But what it does is that Parliament, the composition of Parliament is suspect during that period of time. You see, this is the reason why the Constitution specifies 1 month and 2 months. So, maximum of 3 months you decide.
So, that there is no ambiguity.
No ambiguity. Otherwise, a stranger gets to sit in Parliament for a longer period. So, now for instance, 18th Amendment to the Constitution, the government of the day did not have 2/3 majority when they came in. But they bought away MPs.
Yes.
And they passed the
18th Amendment.
Right. So, that is not right. Soon after the election, see 2010 April was the new parliament convened, and by September they had passed the 18th Amendment. They did not have 2/3 majority at the election. It is entirely on account of these crossovers. So, that is the reason I think there must be the law must be applied more strictly to stop crossovers. And technicalities apart, people know why most of these people cross over. I mean, there are exceptions. There are exceptions, right? But by and large, they cross over for either money or position, and that is a great betrayal. And this is one reason why people have lost confidence in Parliament. This is one reason why they say all 225 go home, because they are not carrying out the mandate of the people.
So, President's Counsel M.A. Sumanthiran, like you said, this is quite a significant decision, and you said it sent chills down certain people's spines. We have the budget, the appropriation bill coming up. We will see how parliamentarians vote on it, and of course next year there is a presidential election that is supposed to come about, but the President also has with him the power to dissolve Parliament, as 2.5 years has lapsed since this Parliament convened first. So, looking at the future, looking at next year, what do you see, what do you predict?
Well, it is very difficult to predict anything at all, because I do not think that the President himself knows what he wants to do. He is floundering at the moment, because he is supported by a group in Parliament who have lost the people's mandate. That is very clear last year. If not, the Prime Minister need not have resigned at that time. The Finance Minister need not have resigned. The President need not have fled the country and then resigned. That is so very clear that they do not have the mandate of the people. Now, it is a false majority that is kept alive in Parliament, and it is that false majority that have elected this President. So, he is beholden to them, and they are beholden to him for not dissolving Parliament.
It's a symbiotic relationship.
Yeah, but this is against the will of the people. It is so very obvious. Right? It is so clear that the people did not want this. So, in that context, now their concerns are how do we stretch this out. We do not really have the mandate from the people, but we are in seats of power. How can we continue? So, local government elections came, no funds released, right, and elections are not held. So, now next year presidential election comes about. The following year parliamentary elections are due.
What do you make of these allegations that they are planning on abolishing the executive presidency in a bid to, they allow Parliament to continue and bring in some interim provisions? Do you think that's a real possibility?
Well, I don't know. I really don't know. But if there is a move to abolish executive presidency, I think all of us should support it. Even if the reasons for that are parochial and selfish and ulterior motives with it, I think any chance to abolish that monstrosity must be supported.
Okay.
Even it may not happen in another way.
Okay.
You see, it is only in some quirky way like this that it might actually happen.
Okay.
So, to get rid of it, I think we should all support it.
We're at the end of the program. Just one final question. Do you think that we should support the abolishing of the executive presidency, even if the bill includes several transitional provisions that will allow this president to remain in power for an additional period of time, and of course Parliament to continue maybe for a couple of years?
That we cannot support. You see, people's sovereignty in terms of exercising their franchise should not be denied. So, extending life of Parliament or any such thing cannot be permitted.
Even if it is coupled with the abolishment of the executive presidency?
Yeah, well, we will have to take a call on that, but I think we cannot deny the people periodic elections at which they express themselves.
So, abolishment of executive presidency, franchise of the people, which is more important in your books?
Well, franchise, I suppose, even reluctantly I might have to concede franchise of the people will take precedence, but abolition is something that we must all seize the opportunity and see that that is actually taken out.
Thank you very much, President's Counsel M.A. Sumanthiran, a parliamentarian from the Tamil National Alliance, for joining us on Newsline tonight. Thank you very much to all our viewers out there for tuning in, as you always do. Until we meet again, take care and God bless.